Hi folks, I'm Anna Sophia Walsh and welcome to the IP Flow Show, where we talk about the hot issues in intellectual property. Today we're joined by Gaston Groub of Markman Advisors. Welcome, Gaston.
How are you doing?
Pretty well. So what are we talking about today?
I think it's a good time to catch up on some of the big developments in the patent litigation world. And really leading the charge is a couple of very important Federal Circuit decisions from earlier last week that have, I think, the potential for significant impact on patent valuations generally, and in particular, patents that are directed to software and other technological improvements. Everything that we've kind of talked about in the past with respect to the Supreme Court's Alice decision.
And what is the significance of the most recent rulings?
Okay, so I think it's so there were two rulings from the Federal Circuit, which, as you know, is the highest court of appeals for all patent cases, other than the Supreme Court. And what happened is the Supreme Court issued its opinion in the Alice case, and that's been applied, as many Supreme Court decisions usually are, has been applied by numerous district courts around the country, literally dozens of opinions from different district courts around the country, applying Alice's two-part test for determining whether or not a patent is directed to what they call eligible subject matter, meaning is it something that you can get a patent on in the first place. And that's kind of been the status quo for the last 2 years, with one exception. The general consensus was that the district courts would more often than not find that these patents were not eligible. And there was one limited Federal Circuit opinion called DDR Holdings, which was kind of held up as the lone exception to the rule. And the lone exception in terms of carving out a space for software-related patents to be found eligible. What happened last week is actually very interesting. There's two decisions that came out within a day of each other. Both of them were penned by the same judge, Judge Hughes on the Federal Circuit, and they both reached very different results, actually. The first decision to come up was in a case called Enfish versus Microsoft, and it had to do with the patentability of a improvement to software databases and database functioning. And the real upshot of that decision was that Judge Hughes and the panel found that Enfish's invention, even though it was written in software and not hardware, could still qualify for as an eligible patent because it was directed to software that actually improved the functioning of the technology, right? So that was considered a major kind of development and further potential extension of the safe harbor created by DDR. The euphoria was a bit short-lived because the following couple of days later, another Federal Circuit panel, again Judge Hughes writing the opinion in a case called In Re TLI Communications, I believe, the Federal Circuit basically reiterated that certain inventions are just not going to be patentable if you use generic hardware and software to achieve something that's kind of expected. Then that's not going to be a technological improvement worthy of patent protection. So between the two decisions, you kind of had the Federal Circuit speaking on this very important issue.
And in light of these decisions, do you think that the courts are going to widen the ambit for software patents, or do you think is there going to be any consistency for the foreseeable future?
That's a great question, and I think there's a couple of things that we can look for. For one, I think for patent holders, now that they have both the DDR decision and the Enfish decision, they're going to have more of an argument as to, yes, our invention actually leads to a technological improvement either through hardware or software or a combination of the two. And perhaps the hope is that having two Federal Circuit decisions is going to have more of an impact on district court opinions, so that it's not just this idea that maybe existed in the past that the Supreme Court said these patents are no good, And why would a district court find otherwise? So I think having now two pieces or two ports of call in the safe harbor potentially will be something that patentees try to hold on to. I think on the defendant side, obviously they're going to argue that whatever patents their clients are being sued under, the lawyers are going to argue actually fall more under TLI and distinct from NFISH. The practical result of all of this is that the battle lines have been drawn, and that instead of relying on 20 different district court cases to make your point, everybody's going to basically be relying on these two kind of pillars and trying to argue that their side of the case falls in within one of them. So I think this might help streamline some of these decisions, and it remains to be seen what impact this has on district courts and how they approach these motions.
Sure. On the basis of these developments, what are you advising your clients?
Well, I think it really comes down to putting a premium on upfronting this analysis, right? Whether we're on the defense side and we're evaluating whether to make an Alice challenge against a patent that's been asserted against us, or if we're on the other side of the table and thinking about working with a client to assert one of their patents. I think the framework continues to be a little bit unclear. Obviously, anytime you have a two-part test set down by the Supreme Court, there's going to be a lot of different ways to apply it, and it's going to be a challenge to get it completely right every single time. But I think now that you kind of have the two Federal Circuit pillars here, it becomes a little bit easier to at least craft your arguments in a way that you think are more likely to lead to a successful outcome. So again, I would say the major change is that the whole idea of collecting district court cases that went your way becomes a little bit less important, and it's easier just to cut to the chase now and say, look, under this Federal Circuit application of Alice, we win, and here's why the other one doesn't apply, and vice versa. It doesn't matter what side of the case you're on.
Okay, interesting. Thank you very much for joining us today, Gaston.
My pleasure.
That was Gaston Groub of Markman Advisors. If you would like to see more content like this, please log on to mimesislaw.com under the IP Flow tab. I'm Anna Sophia Walsh, and I'll see you next time.
Cybersecurity is a massively complex, systemic issue. Both the private and public sectors are wrestling with it. These are threats that affect everyone around the world, from large institutions down to individuals with a credit card and a social security number. All of these issues around cybersecurity are complex in their own right, and the individual threats that we all face are as numerous as the institutions out there utilizing networks. Cypher is here to help you sort through these issues by covering the cybersecurity news of the day and bringing you the facts straight from the experts in the field. Just like the rest of the Mimesis Law network, Cypher will bring you primary source news pieces from the people who know it best. We'll help you sort through the constant stream of information to help you understand the challenges, the technology, the systems, and the cultures leading to the threats we're continuing to face. I invite you to join us here on Cypher, only from Mimesis Law.